What's up, guys? Welcome back to my channel. I'm back with another Donna Adelson video. First, I just want to apologize for my voice. I am sick right now, so please bear with me. So this is an update to a video that I did previously on her that I will link in the comments down below. The judge in her case has denied her motion for a new trial. He has also denied her renewed motion for an acquittal, and he denied her motion to interview jurors because she alleged juror misconduct for two jurors in her case that spoke out after her conviction, which they're completely free to do. So I don't know why she thought she had a leg to stand on. She didn't. We're actually going to go ahead and read the denials right now so we can find out exactly why the judge denied those motions. This cause came before the court for consideration of the defendant's motion for leave to interview jurors, motion for new trial, and renewed motion for judgment of acquittal, all filed on September 15th, 2025. The court, having reviewed the defendant's motions, the court file, trial record, and being duly advised in the premises, hereby finds motion for leave to interview jurors. Defendant seeks to interview two members of the jury in her case, jurors 5 and 7. In moving to interview jurors, the motion must set forth allegations that are not merely speculative, conclusory, or concern matters that inhere in the verdict itself. Consequently, jurors' interviews are not permissible unless the moving party has made sworn allegations that, if true, would require the court to order a new trial because the alleged error was so fundamental and prejudicial as to vitiate the entire proceedings. Defendant's allegations do not establish a prima facie case of jury misconduct, but instead encourage the court to engage in a procedure disapproved of by the Florida Supreme Court in Smith v. State. The argued reason for interviewing juror number 5 is that he revealed he considered how defendant reacted to the evidence and testimony during the trial. However, defendant also notes that juror number 5 expressly stated he did not consider her reactions during deliberations. Defendant's motion concedes that juror number 5 said he did not consider defendant's reactions when deliberating. This challenge primarily concerns that juror number 5 observed defendant's reactions during her trial. By operation of fundamental procedural and statutory rights, the jurors are present in the same courtroom as the defendant. It is not impermissible for jurors to visually observe the defendant over the course of a trial. The Florida Supreme Court in Phillips v. State found the fact that 3 jurors briefly viewed a defendant in his jail uniform was insufficient to warrant a new trial. The facts alleged here fall short of the argued prejudice found as insufficient in Phillips. Accordingly, defendant may not have leave to interview juror number 5. The argued reason for interviewing juror number 7 is that she posted on TikTok that she was selected as a juror on August 26, 2025. Defendant provided a video recording of this post, and the court was also able to locate the post on the juror's TikTok account, where it remains as an active post as of the filing of this order. It displays the following text over video of juror number 7. When I told God I needed a break and he makes it so I'm selected to serve on a jury for a 2-week trial, won't he do it? Along with the caption that reads, "No work, no kids for most of the day. You know what that means. Heaven, yeah." Juror number 7 at Lucy with AJ. The jury was instructed not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. The court concludes juror number 7's TikTok post does not constitute communication about the case. Rather, it was a comment about her jury service and its length. It does not reveal the parties, the attorneys, the alleged crimes, whether it was a civil or criminal case, or even the location of the trial. In other words, it was not about the case. As such, it is not juror misconduct. The TikTok post was not so fundamental and prejudicial as to vitiate the entire proceedings. Furthermore, every prospective juror was informed. If you are picked for the jury, you may tell people that you have been selected for the jury and for how long the case may take. However, you must not give any information about the case itself or the people that are involved in this case. Defendant did not object to the juror being able to disclose that limited information, and juror number 7's TikTok post comports with this exception to the communication prohibition. Defendant cannot now use juror 7's compliance with this directive as grounds to interview her. Accordingly, defendant may not have leave to interview juror number 7. The motion for leave to interview jurors is denied as to both jurors 5 and 7. Motion for new trial and renewed motion for judgment of acquittal. A. Contrary to the law or the weight of the evidence and judgment of acquittal. The court does not find the jury's verdict is contrary to the law or the weight of the evidence. When considering a Rule 3.600A2 new trial motion based on weight of the evidence, the trial court must exercise its discretion to determine whether a greater amount of credible evidence supports an acquittal. The court must weigh the evidence and determine credibility just as a juror would. The court concludes the greater amount of credible evidence supports the convictions. The court relies upon its previous rulings. All direct and circumstantial evidence admitted the evidence demonstrating defendant's consciousness of guilt and its own credibility determination of the witnesses. Stated succinctly, there is evidence in the record demonstrating overt actions by the defendant in furtherance of the M for hire scheme. The members of a conspiracy have more than one objective. The trial evidence demonstrates defendant's objective for the crimes being completed as separate and distinct from her son, the middle woman, and the trigger man. However, their combined acts resulted in the crimes committed and the unaliving of the victim. Because the objective of certain co-conspirators here was obtaining money through criminal acts, the unaliving of the victim did not terminate the conspiracy until the co-conspirators received their payments. The trial evidence established defendant's connection to those payments. Thus, based on the unique facts of this M for hire, defendant's case is distinguishable from William. The court also denies the renewed motion for judgment of acquittal, relying on its denial of defendant's initial motion for judgment of acquittal. All direct and circumstantial evidence admitted, and evidence demonstrating defendant's consciousness of guilt. B. Decision of any matter of law which arose during the trial. The court does not find error in refusing to admit the complete 2014 and 2023 planners. The state introduced particular entries from the two calendars. Defendant asked to introduce complete calendars during its case in chief. As an initial matter, the request was untimely under Section 90.1081 Florida statutes. Although the plain language of the statute requires the adverse party to introduce the other part of the statement at the time that the first party introduces the statement, Florida courts have generally allowed the adverse party to delay introducing the other part of the statement until cross-examination. Defendant's request was too late because it came after cross-examination of the relevant witnesses. Even if the request was timely, it is improper because the purpose of the rule of completeness is to avoid the potential for creating misleading impressions by taking statements out of context. By its very nature, a calendar/day planner is divided into a series of pages corresponding with the days in a year. Thus, the court concludes the entries the state admitted into evidence were not out of context. They were not one part of a whole. They were specific dates in the calendar referencing specific events, and those relevant entries were admitted in their entirety. Interpreting the rule of completeness to allow for every other entry in the calendars would require the contemporaneous admission of any written or recorded statement that might cast light on an admitted statement. Using the language of Section 90.1081 fairness does not require turning a trial into a voyage on a sea of hearsay. Accordingly, the defendant's invocation of the rule of completeness was properly denied. Moreover, the court permitted defendant to use the entire set of calendar entries as a demonstrative exhibit during her closing argument, and the defendant argued that the state did not want the jury to see them. In addition, the 2023 calendar entries defendant sought to admit would not rebut arguments that she was fleeing to avoid prosecution when compared to the vast amount of contrary evidence that existed beyond the planner, such as inter alia, defendant's text messages, WhatsApp messages, Google searches for non-extradition countries, recorded conversations, emergency fast-track visa, and one-way ticket to Vietnam. C. For further cause, the court does not find the arguments presented in this claim warrant a new trial, specifically addressing defendant's decision not to testify. The court relies on the trial record. After defendant had closed her case but prior to the commencement of closing arguments, the parties were asked to approach at sidebar. The court explained it had performed additional research and wanted to confirm that the defendant did not want to testify. The court added, "The reason why I'm bringing this issue to the parties' attention is only because I believe the appellant cases of this case make clear prior to instructions and closing. The exercise of the fundamental right leans toward allowing the defendant to reopen her case if she wanted to testify." Upon the court's inquiry, counsel responded, "We talked to her for somewhat lengthy period of time last night over the phone while we were preparing. She informed Ms. Fulford and my paralegal that she felt secure about her decision. Defendant was then placed under oath and asked if she was absolutely firm about this decision not to testify. Defendant twice responded, "Yes, I am," but asked for a few minutes to talk to counsel. The court then granted an additional 30 minutes to further discuss her decision. After that time had elapsed, defendant once again stated, "I have made a decision. I am not going to testify." When asked if she was firm on this decision, defendant answered, "I am." The court concluded, "I will take no further inquiry unless the state or the defendant seeks for the court to do so at this point." Accordingly, defendant was provided sufficient time to and did make a knowing, voluntary, and intelligent decision not to testify. In denying defendant's other allegations, the court relies on the complete trial record of the proceedings. It is therefore ordered and adjudged that the defendant's motions for leave to interview jurors, motions for new trial, and renewed motion for judgment of acquittal are denied. So I guess it's back to the drawing board for Donna Adelson if she wants to get out, which honestly, I think it's futile at this point. I don't think she's going to get out at all. I think that these points were very weak, but you guys let me know what y'all think in the comments down below. I will continue to follow this case, and of course, I'll be back when she is sentenced. Thank you so much for watching. If you want more videos like this, please subscribe, and if you like this video, please hit the like.